throughout a separation, when the custody of the children is decided, the court often takes the child's best interests into account. So tell me, Diane, what does the court consider to be the child's best interest?
Look, a child's best interest is what you will hear to be the paramount consideration and principle for a court when they're considering arrangements for your child or a child. And it's whether those arrangements are in the child's best interests. So what is best is one of those very discretionary concepts that both parents may or may not agree upon. That's to say, one person considers their arrangement to be best, the other person considers their arrangement to be best. So it's a legal concept, and the court will look at a number of factors when determining if something is or is not in the best interests of a child.
So tell me what the factors are, because that would be really helpful. Because sometimes parents think, I'm the better parent, they should stay with me.
Look, there are two sets of considerations, and the first one is what the court regards as primary considerations, and the second one is secondary considerations, lo and behold. So there is a list under each of these considerations that the court will have regard to and will look to in relation to considering what is best. So we have primary considerations and then the secondary ones.
So what are the primary ones?
So, there are two primary considerations. Firstly, the court must consider the benefit of a child having a meaningful relationship with both of their parents. That is the first primary consideration, and then the court is required to consider the need to protect the children or child from physical or psychological harm. So if the court is of the view that a child needs to be protected, it's important that people understand they will give that much more consideration and greater consideration over and above the meaningful relationship. So they will consider the need to protect the children over the need for that child to have the benefit of a meaningful relationship.
So they're the primary considerations. What are the secondary ones then?
So the secondary considerations, there are a number. To give you some of the main ones that I hear people talk about or that I speak to people often about is firstly any views expressed by a child. So a child's views will be taken into account. But what's important that people understand is the child's maturity or level of understanding of that view will also be considered. People so often come to me and say, my child's 11, my child's 12, they can decide where they want to live. That's not technically correct. Their view will be one of all of these factors considered by a court when determining what's best for them. Other considerations are things like the nature of the relationship the child has with each of their parents and with other persons significant to them, like grandparents, for example. The extent to which each of the parents has been involved in that child's life and maintained them, looked after them. Also, the court will look at the effect of any changes in the child's living arrangements. So to give you an example, if a person, the child is only seeing a parent one night a week and that person all of a sudden wants to increase that to 3 or 4 nights or 7 nights a fortnight, the court will have to look at what impact will that have on the child, if any. So these are what I would consider practical considerations as well. And there are other things the court looks at, like practical difficulty or expense in the child spending time. And that's a particularly important consideration in cases where one parent lives in another location to the other parent. There's a host of other things. The court looks at the capacity of the parents, if applicable. The court will look at cultural issues. So the court will consider if the child is an Aboriginal or Torres Strait Islander child and their right to enjoy their culture. And the court will also look at whether there's been family violence. So the court will essentially look at a host of things and ascertaining what's best. And what's important for people to think about is that the factors that they think the court should consider may not actually be the factors that the court is required by law to consider as well.
It's a minefield, isn't it?
It absolutely is.
So separation is definitely stressful enough as it is, especially when child custody comes into question. So if you have any questions whatsoever, talk to an expert. Give the team at Ruhl Family Law Centre a call today. Diane can certainly help you out.